I stand on my 2 feet. I'm in my proper person. I'm sovereign. I am man. The flesh lives. The blood flows. I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case.
That would be denied.
Along with the officer and sergeant who are already going to be getting sued. There's no need to add you as well.
Any threats to sue me or to take any action against me, I can't be swayed by that. So
it's not a threat. It's just what it is.
All right, everyone. Today we're looking at a court appearance that's anything but ordinary. A self-proclaimed sovereign citizen is back in the spotlight. He claims he's not subject to the court's authority and makes a series of strange statements, including calling himself a living man with blood in his body. Yes, he actually says that. But it doesn't stop there. He boldly threatens to sue the judge right there in the courtroom, which, as you can imagine, is not something taken lightly in legal proceedings. It's the kind of situation you really have to see to believe. At one point he...
Go ahead and have a seat, please. His rights at arraignment.
My honor. So, for the record, I've made this special visitation under duress pertaining to the matters of Jonathan Troy, Faifoleaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-U.S. citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status. And so I ask you, ma'am, what is your name? What is your nationality? And what is your status?
I'm Judge Grant. I am a citizen and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I challenge the jurisdiction. And jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued, it would just add to that. And I don't think that you need to go that route.
While I review this incident report. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the law.
Unless you want to enter a plea of guilty, today there'll be a plea of not guilty. I understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven.
Questions the court's jurisdiction, even though he's in handcuffs and wearing a jail uniform, clear signs that the court does, in fact, have jurisdiction. His arguments seem to come from internet misinformation rather than legal fact, and his confidence far outweighs his preparation. You'll notice he keeps insisting the court prove its authority over him, but
status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-U.S. citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but it looks like you have a driver's license that recently expired.
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
All right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating.
Again,
the traffic laws.
I was not driving. Again, I have rights.
You were
And
behind.
my rights were violated.
Traveling.
My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am
you.
sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him.
Legally, that's not how it works. The burden of proof usually falls on the one making the challenge, not the court itself. While this isn't the most extreme sovereign citizen we've seen, his behavior still raises serious concerns. Based on his attitude alone, it's hard to believe he'd follow the law if released. There's a real sense that he doesn't take the situation.
I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also, indication that Mr. Schuster will not abide the court's orders to appear on his promise. Want to look at the Seattle municipal case and see when he's next scheduled to
Like
appear.
you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale Maliatoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
And throughout this process of going to courts, I've had to learn a lot. And so I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I do not.
I don't see another date set until February 12th of 2025 in the Seattle
In
case.
Seattle Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail, and any threats to sue me or to take any action against me, I can't be swayed by that. So
Well, it's
you
not
can
a
do
threat. It's just what it is.
And seriously, and that's a problem. And then perhaps the most shocking moment, he directly threatens the judge by saying he'll add her to his lawsuit if she doesn't let him go. That crosses a serious line. Threatening a judge is a major offense, and many people might have expected a more forceful response. That said,
Because my rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
When are you setting that court date, miss?
Required by the Department of Licensing. You are, you will be represented because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented by anybody. I stand on my own 2 feet.
These are criminal charges that have significant consequences for you. So it's in your best interest to have counsel.
Again, I
assist
stand
you.
on my own 2 feet. I do not need to be represented by anybody. I present myself sui juris in propria persona.
If you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-U.S. citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights, and I do not need to be represented by anybody.
All right. The time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be,
We want to try for next Wednesday or even the week after that.
well, next Wednesday's a holiday, so the 18th, which is pretty full. So I was going to set this on June 24th. That's 2 weeks out.
So for the record, you have not established status. You have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench.
Sign for your next court date.
You're asking me to sign something that you pleaded for me. Is that
Yes,
correct?
I'm giving you notice of the conditions that I have set as well as bail.
You said,
I'm
yes,
noting
you
that I
pleaded for
found
me.
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice, and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have a?
I
piece
do
of
not
paper
understand how
with
you can
the
practice
document?
law from the bench.
I'm the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty, so on your behalf, I'm entering a not guilty plea.
So, correct, you
cannot-
are pleading for me,
There's
correct?
two pleas.
And if you
Not
plead for
guilty
me,
or
you're
guilty.
practicing law from the bench. You cannot practice law from the bench, so I object.
Right.
You're-
I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay? All right.
Jennifer Grant, you will be
Okay.
taken further.
The judge remains calm and measured throughout the hearing. Some viewers might think she should have been stricter, while others may believe she's playing it smart by letting him continue to speak and reveal more about his mindset. That in the end, things didn't go the way he expected. He didn't walk out of court a free man, and his legal strategy, if you can call it, that clearly didn't work. Let us know what you think. Should the judge have responded more strongly, or did she handle the situation just right? I'll be posting the second part of this hearing soon, so be sure to stay tuned for that. Thanks so much for watching. Don't forget to like and subscribe if you enjoy this kind of courtroom content. I post new videos daily. Take care, and we'll see you in the next one.